Judgment has been reserved in the Western Cape High Court in the case challenging MK Parliamentary leader Dr John Hlophe's designation to the Judicial Service Commission. Democratic Alliance lawyers are arguing that Parliament should have exercised discretion when the MK party nominated Dr Hlophe to serve on the JSC. Let's get more analysis on this now by welcoming Cathleen Powell, who's an associate professor in public law at the University of Cape Town. Prof, thank you so much for making time to be with us today. Welcome. So, judgment reserved in the matter, but let's get your expert opinion on the applicants in the matter, namely the DA along with two other organizations. So please help us dissect their submissions, which is based basically on the view that the parliamentary processes that actually led to Dr Hlophe's appointment were in fact irrational in that he is an impeached judge.
Thank you and good afternoon. Yes, there are three applicants and they're bringing slightly different applications. Two of them are asking for an interim ruling by the court for the main merits to be decided later, and Freedom Under Law is actually asking for a final ruling straight away. But what they're trying to do is firstly prevent former Judge Hlophe, so Dr Hlophe, from actually serving on the JSC. And the JSC has meetings in October already. And secondly, they're presenting the substantive case to show that Parliament was not allowed to appoint Dr Hlophe to the JSC. And yes, the bottom line is he's a disgraced judge, but that's not enough of a reason for the court to hold that Parliament could not have done that. So they've brought some very clear, well-substantiated arguments about how the NA, the National Assembly, should not have delegated the decision of which people to appoint to the political parties, and it did in this case. It allowed MK simply to nominate somebody. One of the arguments is that the NA should have made its own decision on whom to appoint. That was one problem. The second one is that when you're appointing somebody to the JSC, you're appointing somebody who is meant to ensure the integrity, independence and good reputation of the judiciary. And they are saying it's irrational to be in pursuit of that goal and then appoint somebody who has been found to disgrace the judiciary on exactly those points. Mm-hmm. So
yes, Prof.
No, go ahead.
Yes, Prof. I was saying, following the proceedings, interestingly enough, one of the presiding judges actually brought a very interesting remark that Parliament has set a precedence in how they actually conduct their businesses, in this case, appointing members to the various parliamentary portfolios. And he also pointed out the fact that such a motion has never been brought before a court, and wanted to know what the applicants who lost similar arguments in the National Assembly have now brought this matter for litigation with the MK Council, calling this jungle law. I'm sure you remember that reference by Advocate Dalimpofu. Is this not then directly asking the court to run a parallel tribunal as suggested on parliamentary processes pertaining to the separation of powers?
Actually, no. It was the first thing that worried me when I heard about this case. But having had a closer look at the applicants' heads of argument, I realized that that's not a problem in this case. Firstly, on the question of Parliament's conventions, Parliament's long-standing practice, none of that can override the Constitution, and the rules of Parliament say as much. So the fact that there's a long-standing convention means nothing if that convention is constitutionally faulty. So that's not a problem. Secondly, the convention, it did relate to the appointing of people to the JSC, that is correct. But what they were trying to equate the appointing of the people to the JSC to was appointing people to parliamentary portfolio committees, which is the term you used, the term you're quoting. Now, the JSC is not a parliamentary portfolio committee, because it's not just the NA that appoints people to the JSC. It's all sorts of people, including members of the profession, advocates, attorneys, and so on. So the NA is just one of many bodies that helps to set up this body, the JSC, which is an organ of state, but it's not a parliamentary portfolio committee. So the process for appointing people to the JSC as opposed to appointing them to the parliamentary committees is different and is subject to administrative law according to the applicants in this case, and I think they make a good argument.
And then, I mean, Prof, this then has also brought some comparisons and raised some questions to DAMP, Ms. Glenys Breitenbach. But of course, this is not particularly the same situation. So how would you then define the differences between the two?
I am not aware of a finding against Glenys Breitenbach impugning her integrity, her respect for the judiciary, or her independence in running her job. So I think that's all the difference you need to find. Remember, the Constitutional Court itself has said that the purpose of the JSC is to appoint judges of suitable quality. That's how the Constitutional Court put it. And that means that the NA, which has the job of deciding whom to appoint, even if those people are nominated by political parties, the NA as a whole has to decide whether to appoint people, and it has to work out then whether these people are suitably qualified. And the applicants, I think, simplest and strongest argument is the NA simply didn't do that. They said, okay, the MK wants this guy, so we'll put him in. And that person that they wanted, Dr. Hlophe, unfortunately was not suitably qualified because he had been found, and in fact is on a continuing basis, breaking down the good standing and the integrity and independence of the bench. And he made it clear in his own affidavit that he's going to carry on doing what he was doing before, which is such things as speaking to judges about how they should be deciding cases. Now, there's case law that's already said, no, that is highly improper for a judge. You should not be doing it. And he said he's going to carry on doing it. So he's not suitably qualified, sorry.
And in closing then, Prof, I mean, moving forward, maybe just give us a little bit of insight in terms of what type of lessons can we then as general society draw from this, and also, I mean, is this not setting precedents for other appointments by the NA to the various portfolios that could then be brought, of course, before the courts to make a final ruling upon?
Look, there's always some anxiety when courts are asked to rule on something that the NA has done, and for good reason. But I don't think the panic factor need be quite as bad here. First of all, as I said, we're not talking about appointments to portfolio committees. There, the NA is simply handling an internal matter and should be allowed to do its own thing most of the time. The court always has to be careful not to intrude on the domain of the NA. But this is not exclusively the domain of the NA. This is the JSC, to which a number of bodies are meant to nominate members, and for which administrative law and the terms of the Constitution requires a certain level of applying of one's mind, shall we say, to the decision of whom to appoint. So I don't think we need to get worried that whatever decision is made here, assuming the NA decision is overturned, I don't think we need to worry that that's automatically going to mean every decision of Parliament is now going to be taken to the courts. There are a couple of major differences between this case and certainly appointment to parliamentary committees. Admittedly, there might be other places where the NA or the NCOP as well, and where there might indeed now be more case law challenging the NA and the NCOP's decision. However, all that the applicants are here really saying is that the NA or the NCOP should be applying their minds and substantiating their decisions. And if they do that, they should be safe.
All right, then I want to backtrack a little bit, Professor, because I still feel that we need more clarity on this, right? So maybe take us through what the exact constitutional directive enshrined in our constitutional law actually mentions, because of course, the respondents were arguing that it doesn't mention impeached judges. And the presiding judges also alluded to the fact that, of course, this is a first time that an impeached judge has to be considered in this regard, because the section only makes reference to the former president not being able to then assume public office.
Correct. There are no explicit provisions for what happens to former judges who are no longer judges because they were impeached in the Constitution. That doesn't stop all of the general principles from applying, and it doesn't stop the other principles in the Constitution dealing with the judiciary and the JSC from applying.
All right.
Now, do you want me to go through those, or have we run out of time?
Unfortunately, Prof, we've run out of time, but thank you so much for your input this afternoon. Professor Cathleen Powell, the University of Cape Town, on the DA challenging the designation of Dr. Hlophe.